stand part. Point of order.
I seek leave for all provisions to be taken as one question.
Leave is sought. Is there any objection? There is no objection. Oh, there is objection. The question is at clause 1 stand part. All those in favour? Oh, sorry. The question is at clause 1 stand part. Carl Bates.
Yes.
Here we go. He's up.
Sorry, Mr. Chair, I got confused by my diligent colleague from Takanini. I thought was going to ask the first question. First of all, can I just take the opportunity to congratulate the member, Camilla Bellich, for taking this diligently through the education, the hard-working Education and Workforce Select Committee, and for the various oral hearings or oral submissions and written submissions that we had the opportunity to engage in, and for the thoughtful debate we had through the committee stage. Mr. Chair, my first question just relates to why the member felt it appropriate for a bill of this nature that's relating to theft to be dealt with by or through employment law components. I suppose rather than it, for example, being a personal grievance and being dealt purely in the realm of employment law, this particular amendment will amend the Crimes Act and therefore becomes a piece of criminal legislation, I suppose, and sit within that realm. It was dealt with by the Education and Workforce Select Committee, and so I felt or feel that it would more naturally sit as, or should have sat as an employment law issue, something in the realm of personal grievance, something that could be dealt with by the likes of more traditional personal grievance type processes. But rather than that, we've got a piece of legislation that is going to involve other agencies such as police, is potentially going to or could involve the courts because it is a crimes piece of legislation. Now, you know, ultimately, for how often the opposition talk about their concern around us filling up our prisons with too many prisoners, could ultimately result potentially in people filling up or clogging up our justice system. And so, Mr. Chair, my first question, I have a number of questions as we go through the different parts of this amendment this evening. My first question is in relation, as I say, to why we are dealing with this under criminal legislation as opposed to employment law purely. I'll leave it at that point, Mr. Chair, and ask my next question in hopefully a few minutes' time. Thank you.
Camilla Bellich.
Thank you, Mr. Chair, and thank you to the member for that question. The first part of his question on why it's in the Crimes Act as opposed to a personal grievance is really the entire purpose of this Act. It's to recognise the fact that there isn't a criminal sanction available for employees who suffer theft as a result of the actions of their employer. So that's why it's in the Crimes Act. In terms of the Education and Workforce Select Committee, that was referred to the Education and Workforce Select Committee by the 53rd Parliament. But as the member is aware, the Ministry of Justice did provide advice to the committee and so was well served from that purpose. In terms of the wider issues around theft by an employer being a crime, this is not new in New Zealand law. There are existing provisions in the Immigration Act which criminalise theft by an employer for recent migrants, and often, and inequitably in my view, employees who do steal from their employers are referred to police and treated in the criminal law. This bill is merely about addressing that imbalance.
I just will remind the member that to be aware that this is about the title, this section, having voted to do it section by section. I did allow it though, but just any further questions, be reminded that we are doing this part by part. Carl Bates.
Thank you, Mr Chair, and point well noted. I will focus on that first part then being the title. And I suppose when looking at the title, and while we didn't discuss this in any depth in the Select Committee, Mr Chair, I think it is important for us to consider at this point in this Committee of the Whole House stage what the appropriate title for this bill could be. And I've given some thought, Mr Speaker, to the members' intent behind bringing this piece of legislation to the House and whether the focus on employer or employee, who it is exactly that the member is looking to protect or create harm for through this amendment. And I wondered, this title, Crimes, Theft by Employer Amendment Bill, if it would more appropriately be named something like the crimes, brackets, we think all employers are thieves, bracket, amendment bill. Because certainly through the process of the Select Committee, it became clear that a number of the submitters seemed to think that it would be natural for employers to want to do this, that employers don't value the contribution that their employees make. Indeed, during the Select Committee stages, as some of my colleagues may recall, there was not data able to substantiate the size of the problem that the member is trying to solve. And so, that's particularly concerning to us on this side of the House, Mr Speaker, as we think about what we can do to get New Zealand going, to make sure that we improve productivity in this country, that we can focus on raising wages, raising salaries of employees. Frankly, when I'm door knocking like I was on Sunday in Whanganui, meeting members of my constituency, the everyday worker, Mr Speaker, their focus was on how their wages can increase. And my concern with the title of this bill, Mr Speaker, is it suggests something that is softer than the underlying intent. Certainly some of the submitters, maybe I could go as broadly as saying some of the unions who submitted on this bill, their views towards employers. And I think if the true sort of intent, the true understanding or feeling behind those that did support, or many of those that did support this amendment bill was appropriately reflected in the title, Mr Speaker, it may encourage some of my colleagues around the House who may be inclined to vote for this amendment bill to reconsider their position, because I'm not sure that anyone in this House really actually wants to call employers thieves, and I think that there is a intent, a feeling, if intent is too strong a word, a feeling behind this amendment bill that there are many more employers, Mr Speaker, that have this intention than was the reality. Because certainly in the data, and I go back to the submission process, Mr Speaker, there wasn't data that was able to be provided that substantiated the true size of this problem, if there is really a significant problem at all, that was able to be provided to the Select Committee. And so, Mr Speaker, I would encourage the House and the member to consider ensuring that the amendment bill reflects the real feeling behind those that wanted this amendment to pass. And I would be interested, Mr Speaker, in the member's view of reflecting the true intent of the title in the title itself, as I have suggested, Mr Speaker. If the member is not open to my first suggestion on the title of this amendment bill, Mr Chair rather, I'm happy to provide alternative suggestions as the course of this evening goes on. Thank you.
Mr Chair. Kamala Belich.
Thank you, Mr Chair. I don't think that is a good suggested alternative name for the bill. I think this is actually a really well-named bill, and so I don't consider that we should be considering any alternatives to that. I would like to just reject the member's allegation that this is about calling employers thieves, or that there was any suggestion that all employees are involved in this type of behaviour. Of course, we know that most employers, the vast majority, are very good employers, just like most New Zealanders, but there is a place for the criminal law in New Zealand when crimes are committed. And it is somewhat ironic to hear members of the government side complaining about a bill like this, which would simply treat employees in the same way and simply treat employers in the same way that employees are treated. An effective example of balance, which from today and in recent days we've been hearing the Minister for Workplace Relations talk about. This is a perfect example of balancing fairness for employers and employees, and it is a tough on crime bill. And it is very ironic to hear members of the National Party stand up and take calls wanting people who have committed crimes against their employees not to face justice as a result of that. That is the effective nature of that submission, and something that I reject. I also want to thank all of the submitters for submitting on this bill. It's not an easy thing to submit on a bill in Parliament. I reject the members' characterisation of those submissions, and I also would like to refer the member to the information provided by the Ministry of Justice in their report to the Education and Workforce Select Committee, which set out in detail the data available in relation to wage theft cases in New Zealand.
Mr Chair.
Grant McCullum, but I just will remind members that it's unusual that we're having the title and commencement at the beginning. So just a reminder that we will be strict on what we're actually going to be discussing in the question. So Grant McCullum.
Thank you, Mr Chair. I appreciate that. Firstly, like my colleague, I'd like to congratulate the member for having her bill in the Parliament. Well done, and it must be a real privilege to be able to do that. Look, Mr Chair, I suppose I would question the title of the bill. I wonder whether it's aptly named, having sat through the submission process in the Select Committee and listened to the submitters. I do just wonder whether it may be better named Crimes We Don't Trust Employers Amendment Bill, because that was the kind of the theme that came through, actually came through. It actually would be probably better reflect where this bill is actually coming from. It's about lack of trust in employers, and that just means. And that puts a lot of extra pressure on employers. If we're going to name a bill, we should actually have the name reflect what it actually is and what it actually does. And actually the other word in there is crimes. Is that an appropriate thing to note and call where you're talking about people that actually may make a mistake around the payment of or not otherwise of their bill of their wages and salaries. I think crimes is far too strong. It puts a lot of pressure, unnecessary pressure onto the. This is about the title of your bill. It's about the title. The honourable member on the other side doesn't seem to like what I'm saying, but that's fine. This is all about making sure that we get the appropriate title, and it's really important that we do that. And disappointed that the member can't see the logic of that. And maybe if that member had sat through the process himself, they would have actually been able to see what was being said, and then would appreciate the new title that I'm suggesting, because it is about trust and the lack of trust that some see in their employers, and that, I think that's a sad thing in our society. So I really would urge the member to consider renaming this bill in a more appropriate way, because I think actually what it says now is far too strong on employers. Thank you, Mr Chair.
Mr Chair.
Carl Bates.
Thanks, Mr Chair, and thank you for your guidance, Mr Chair, regarding the stage that we are at this point in the committee, and would look forward to taking your guidance as we move through, that we're moving through at a pace that you are comfortable with, Mr Chair. But for now, I take it we are still considering that title as the first part, and if I'm mishearing you, Mr Chair, happy to take your guidance on that. But the title itself disconnected, Mr. Chair, from the intent. And so I just want to focus for a moment on the lack of clarity that came through the submission process about the point at which this Act would be triggered, because this, Mr. Chair, relates to the title and an alternative concern I have around the underlying bill, particularly in relation, as I say, to when an employer could be caught out. So by way of example, and I need to share the example in order to get to the point of sharing the potential title that I would ask the member to consider as an alternative to the two that we have just suggested. And that is that an employer, through, for example, a mishap in banking that didn't pay their employee under the current wording, and I appreciate that there is an amendment to the amendment, and that suggests that maybe this bill is not drafted as well as it could be, because we've got to now make some amendments to the draft bill. But under the current wording, if an employer didn't pay their employee because there was a mishap with banking, or let's say, for example, they thought they had enough money in their account and it happened that there wasn't, and employees didn't get paid and they didn't realise that this was the reason, and it took some time to sort it out, that the employer could be caught out as having stolen from their employees. So, Mr. Chair, I wonder if the member would consider, as an alternative, as an amendment to that, crimes, bracket, theft, bracket, even if it is an accident, close bracket, by employer amendment bill. Because I am concerned, as came up in the amendment bill, about what the trigger is for when an employee could be caught out, an employer rather, could be caught out in terms of having, inverted commas, stolen from their employee. I think, Mr. Chair, that is the last of the suggestions I have at this stage around the title, and we'll be happy to move on to the substantive after the member has responded, if she so wishes, to our suggestions. Thank you, Mr. Chair.
Shannon Halbert.
I move that the debate on this question now close.
Dr. Vanessa Winnick.
Thank you, Mr. Chair. It's so rare that I stand and take a call other than to move a motion like the previous member just did. So to be asking a question on this very important thing, which is the title of this bill, because names matter and words really matter. And so I just wanted to ask, in your consideration of the use theft, given that some of these things are happening in regards to people's pay potentially, or other benefits in their employment, did you consider using the word pilfer or pilferage by an employer? Because that is really a much better description of the kind of things that we are dealing with. Or peculation or rapacity. These are words that potentially could have been better used. This is the kind of thing where a good descriptive word can help to better give your intent of what you mean when it comes to the kinds of low level of things that we actually see happening. And it was mentioned by my colleagues that there's not really much evidence of there being a huge number of crimes in this matter, or a big problem that we're trying to solve. And I just think that this is one of those examples potentially where we've got a bill that's looking for a problem to solve, and it isn't really, it's not necessarily that we've got a huge background problem here that we're trying to amend. And so just thinking further on these titles and these words that you've got, just really interested to see how much you dug into that, and whether you've given any consideration to anything else. And I'll leave it there for you to give us your wisdom.
The question is that Clause 1 stand part. All those in favour say aye. To the contrary, no. The ayes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 opposed.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
6 votes in favour.
The ayes are 63, the noes are 60. The question is agreed. Members, we come now to Clause 2, and this is the debate on commencement. The question is that Clause 2 stand apart. The question is, I'll just say you sneaked in there, Mr Bates. No, if it's about whether he's entitled, I hadn't actually started to close, so no. No, you don't care what you heard. I've given the call to Mr Bates.
Thank you, Mr Chair. Thank you for your generosity this evening. And I think, Mr Chair, this sort of demonstrates my concern about the commencement date, that businesses have a lot going on, Mr Chair, and throughout businesses that are trying to grow the salaries and the wages of their employees by becoming more productive, by growing the New Zealand economy, by being able to do the stuff that actually puts money in the pockets of New Zealanders, Mr Speaker. I'm concerned about the timing of the commencement. This date of commencement, the Act comes into force on the day after the date on which it is received, or it receives, the royal assent. This could be any given random day in the business week, Mr Speaker, or in the business month, or indeed, I suppose, in the business year. And I think that there would be value, Mr Chair, in giving some consideration to a timing of a commencement date that more appropriately reflected the times or the business cycle of the business year, the life cycle, if you like, of business. And there are a number of dates that become the life cycle of business. One particular date is the start of the financial year. And I wonder, Mr Chair, whether the member would be willing to give consideration to commencing the bill on the first day of a new financial year. That gives an opportunity for communication around this change to effectively go out to all employers so that they are clear on this additional burden to their job as employers that the opposition has put on them. Because let's be clear, Mr Chair, it will be the opposition and friends, if this goes through this evening, that put this on. But, Mr Chair, if it is the case that this bill goes through this evening, that timing that aligns to a date that employers are going to be able to be communicated effectively that that's the start date. Now, the first of this financial year, being the 1st of April 2025, is probably too soon, given by the time this goes through, gets royal assent, and then actually, goes through the administrative process, and then we've got to communicate it out. So in that regard, the supplementary question to my question would be, would the member consider aligning this, if it was to pass, for the commencement to be the 1st of April 2026, so that, first of all, it is aligned, as I've said, Mr Chair, with the life cycle of the business year, and that naturally sits at the start of the financial year, being the 1st of April, and then secondly, allowing sufficient time for not only the communication out of this House to get through to employers through appropriate different channels, but also for HR practitioners to get the appropriate upskilling and uptraining, because the opposition always, Mr. Chair, go on about the importance of people being upskilled, professional development when there is a change. This is a change for HR practitioners to be aware of, and it's important they have the opportunity for professional development so that they are clear on this change before it goes into action, into commencement. So, Mr. Chair, as I say, aligning it both with the business life cycle, the start of the financial year, and ensuring sufficient time for employers to be made aware and for the support that they have, because in this country right now, if you are trying to drive productivity up, you need all the support you can get, and many employers, small businesses and the like across this nation use HR practitioners to support the implementation of their HR policies. And so, Mr. Chair, I would encourage the member to consider both of those commencement questions. Thank you, Mr. Chair.